Investigation. Let's talk about investigation for a minute. Did the defendant investigate this incident? Great. What did you do? What did you find? And then they'll tell you. And then you find out about what they did or didn't do. No. More times than not, it's a no that I encountered. They didn't investigate it, which always is surprising to me. And I have a lot of examples where you'll have like someone, you'll have this case is a deck collapse case. You can use timelines effectively. I brought these as demonstrative things for y'all. So you can put these things on demonstratively. This shows events, and you can take it, especially a long, complicated case. This is a deck repair case. They repaired all the other decks and never look at this one that collapsed and never investigated it. This is the only deck collapse that they had in 30 years where someone was injured, but they never investigated it. Are you kidding? Really? But they had all these other deck collapse problems as they went along. You have an employment discrimination case where you have a company for 20 years and they've had one sexual harassment complaint. It's your case and they never investigated it. Really? Give me a break. It's because they're trying to hide the ball or they're not looking. And I think that the jurors expect someone, if they err, to look at it and assess it. For the defendant, on a subsequent, where that happens and it's a subsequent remedial measure, admit it. The instinct for defense lawyers is, I don't want to get into that. I don't want to tell you. I'm not going to give it to you. I'm going to object to you. In a way, as a defense lawyer, you may want to double down on it and own it and say it's a subsequent remedial measure, and then it doesn't come into evidence. I was trying a case in front of Judge Bush one time, and we were arguing before closing argument, and they were trying to say that I couldn't talk about firing a bus driver right after an accident. And the defense lawyer was really fighting on admitting that it was caused by this accident. And the judge said, well, if you don't think it was caused by this accident, then Berger gets to talk about it in his close. And then he kind of came around and said, yes, it was from this accident, and then I couldn't talk about it. So on the subsequent remedial measures, yes, they're dangerous. Every plaintiff wants to get that evidence. But from the defense point of view, I'd suggest that you admit, if you got it, you better connect it from that, because then it won't come in against you. Yes, it can come, yes, and you got to be careful at trial, because the subsequent remedial measures can come in. You know, you can open the door. You got to be careful. It comes in for control, for admissions, for other issues. So there are exceptions to that rule, but you got to know those and avoid them.